First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We have one case on the docket today, Rochelle versus State of Florida, with 20 minutes per side. Is the appellant ready to proceed? You may.
Thank you, Your Honor. May it please the court, I'm Phil Padovano for the appellant Mike Rochelle. I'd like to reserve 5 minutes for rebuttal. Your Honors, there were a number of serious errors in this case, but I'd like to begin, though, with the trial court's failure to allow the defense to review Mrs. Rochelle's mental health records. Early on in the proceeding, the defense filed a motion to examine records of 4 mental health providers, one a licensed mental health counselor, a PhD psychologist, the Shands Teaching Hospital in the North Florida Women's Care. All of these healthcare providers had information concerning mental health treatment of the alleged victim, Mrs. Rochelle. And the motion alleged that this was an issue because her mental state ended up to be front and center in the give and take of the prosecution and defense of the case. The trial judge looked at the records in camera and made a determination that there was one statement in those records that was relevant, but then ultimately denied the defense to see any of the records. The defense never saw any of the records. The error in this was that the trial court applied the wrong standard to it. The trial court actually applied a 9403 standard, which is the standard for admissibility of evidence, when it should have been whether this evidence was discoverable. And as this court knows, the court has precedent saying that a request for discovery should be granted if it is reasonably calculated to lead to admissible evidence. So we don't make a determination yet at the discovery phase whether something's actually admissible, but that's what the trial judge did. Now, on this record, I think it would be impossible for this court to say that this request was not reasonably calculated to lead to admissible evidence. The defense was that Mr. Rochelle attempted that she was the aggressor, that she had way too much to drink, that she was drunk, that she was violent, that she tried to kill herself, and that he stepped in to try to prevent her from committing suicide, and that's how the injuries occurred. What we know, that's his story. We don't know whether that is correct or whether her story is correct, but what we do know is that she did have evidence that her wrists were slit. We do know there was expert testimony that those injuries were consistent with self-inflicted wounds. We do know that she had a 3.5-year history of suicidal ideations, multiple texts written back and forth about suicide, some of which the jury, well, none of which the jury saw, actually, and that's another issue in the case. But my point is, the evidence was overwhelming that this was a legitimate issue in the case. This wasn't something that was done just to pry into Mrs. Rochelle's private affairs.
Well, can I ask you, Mr. Padovano,
Sure.
about the state's, preservation argument? During the hearing on the motion to compel, defense's trial counsel, your client's trial counsel, said if the court feels more comfortable doing an in-camera inspection of these records and trying to determine what would be accessible by the defense, I have no objection to that. Then ultimately Judge Davis did the in-camera inspection and said, okay, you don't get any records. And my understanding is after that ruling there was no further objection or no renewed request or anything like that, right? So why is any of this preserved? He got, your client got what he asked for.
Well, first of all, he didn't get what he asked for. He didn't get anything. I mean, I think he said in that little passage that you read that he was interested in the night of information about her mental state on the night of. Didn't get any of that. So we got nothing. I mean, absolutely nothing. That alone would be, I think, ground for reversal. But let me put that that issue, I know that's the state's argument, and let me put that in the proper context. At the time we had the hearing in this case on that, the court had not yet ruled on whether this was privileged. So the parties were operating under the assumption that this evidence was, or that this information was subject to the psychotherapist patient privilege. Of course, later, it determined that, the trial court determined that the privilege had been waived because these records had been given to the civil lawyers and the privilege was waived. But I would say this about it, Your Honor. The motion itself is broadly worded. It talks about her mental intent, her mental status being an issue in the case. And I know that the state says, well, we didn't bring it up afterwards. But I don't know of anything in the law that requires us to argue with a judge about his ruling. I mean, he ruled on it. He said we weren't entitled to have it. So, I don't think the trial lawyer should be in a position to have to argue with a judge about the ruling.
Would you agree that at the hearing, the scope of the request was substantially narrowed, where counsel said, I'm concerned about finding out alcohol dependence, amount of alcohol she may have consumed on the date in question, and the specific medication she may have been on the date in question, so I can do further expert testimony. And ultimately, there was that expert testimony that testified to at least everything but the alcohol dependence.
Well, his expert testimony, we don't know what these witnesses from the mental health care providers would have offered in that way. I'm sorry, did I don't know if I answered your question.
I guess that goes to the state's point, though, that even if this was error, then it's harmless because your client was able to get into all of these matters at trial.
Well, let me address that in two different ways. First, I don't think it can be harmless because, as this court said in the Traffenstead case, and I believe you were on the panel in that case, this is a denial of due process of law. So it doesn't matter too much what the lawyers did or failed to do because due process violations are fundamental error. So I think that if you're concerned about that, that could get you past that point. And I should say also, Your Honor, that I think this case presents an even stronger case for reversal than Traffenstead because there you were dealing with evidence that was necessary to overcome psychotherapist patient privilege. Here we're talking about a plain vanilla discovery issue. How could the judge say that this was not reasonably calculated to lead to admissible evidence? Clearly it was. So I mean, I don't think there is a preservation error, and even if you were to conclude that there is, it seems to me that under the Traffenstead case, it's a due process violation, which makes it fundamental error. The judge said, well, there wasn't any evidence, speaking of the suicide attempts, there wasn't any evidence that she was ever successful at it. And I think that really kind of misses the point. I mean, she had a long history of suicidal ideation. And, this goes directly to his defense. I mean, it goes directly to his theory of the defense. And it's not as if it was a fanciful defense. I mean, there were injuries that were consistent with suicide. So I think if you have a concern about that, the answer to it is he didn't even get the limited thing that even if you think that the request was limited to a certain thing, he didn't get that. He didn't get any of that. And I don't know how it could be justified that he wasn't entitled to that under the facts of this case. So let me move on now to the point about the suicide text, because I think it's closely related to this point, and it's kind of related to all of the points, I think, in the argument. The judge, there were numerous texts in which Susan Ruschel wrote to Michael Ruschel telling him that she was going to commit suicide. This went on unabated for a period of 3 years prior to the crime. The judge didn't let any of these texts into evidence because he thought they were hearsay. He ended up saying, well, you can cross-examine her about that. But I don't think that is any substitute. If these were not hearsay, and I think they were not, the defendant had a right to present them. He had a right to present his case the way he wanted it tried, not the way somebody else thought it should have been tried.
But the evidence can't be too attenuated or remote, though, right? So he was able to get into the fact that she had some suicidal ideation.
He was able to get into it, Your Honor, in his own testimony. But let me explain how that really doesn't answer the question. Here this man is on trial for attempting to kill his wife in front of an all-female jury, and they have to take his word for all of these things that were done and all of these things that were said.
Didn't she also admit to the suicidal ideation?
She did, but it pales in comparison to the impression that would have been created by the texts themselves. And so my point is, if the texts themselves were not hearsay, and they were not, then he had a right to introduce them.
How do you respond to the state's contention that the communications regarding the suicidal ideation and actually the appellant's willingness to grant a divorce were too attenuated, too remote to fall under a present state of mind?
There was no break in the action. They were continuous. They continuously, there were several batches of emails that went back pretty much continuously for the last 3 years. And the way I react to it is by the text of the evidence code. The evidence code says, as an exception, a statement of what is not hearsay is a statement of the defendant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, or motive. Now, if suicide ideation is not a statement of emotion, I'm not sure what would be. If it's not a statement of plan, I'm not sure what would be. If it's not a statement of intent.
Well, you would agree that at some point, though, it's too remote. So if, as a teenager, she had threatened suicide.
If these threats had occurred in text that were, let's say, 3 or 4 years old, and there was absolutely nothing but clean mental health in the meantime,
Right.
maybe.
Maybe. Would that not then fall under the trial court's discretion on an evidentiary issue to decide? We decide whether this was an abuse of discretion, and a reasonable trial judge might see it one way, a different judge might see it another, so it's fair game.
Well, I don't think there's. I think as a technical point, yes, you're right that would be. I guess the remoteness part of it would be a discretionary call, but I don't see how you can make that call here, particularly in light of the Vanier case, which talked about suicide letters, and in that case. It was a little bit different, but it's basically the same issue. The question was whether letters written by the decedent, this was a homicide case, the question was whether letters written by the decedent were admissible. And it wasn't even clear that the letters reflected suicidal ideation. One had to sort of interpret them in that way. And the court said, if the proffered evidence would have any tendency, however remotely, that's the word the court used, or indirectly, to convince a juror that the decedent's death came from her own hands, it must be deemed prejudicial to have excluded it. The court said because suicide was the defendant's theory of defense, same thing we have here, exact same thing we have here, any evidence that tends in any way, even indirectly, to show the death was from suicide is admissible, and it's error to exclude it. So there you have in the Vanier case a situation in which there were prior letters about suicidal ideation, which it was debatable whether that was even the case. You had to have an expert witness say, yes, I think that's what this means. Here you have a woman who's saying, I'm going to kill myself. The world would be better off without me. I'm going to look to see how it's done. I'm going to drown in the pool. I'm going to buy a gun. No, I'm not going to buy a gun because then he'll find out I bought a gun. Over and over and over again for 3 years. How is this not relevant? How is this not admissible in a trial where a man's defense was that he was trying to stop a suicide? So I don't know, Your Honor, to answer your question, I suppose the remoteness part could be perhaps discretionary. There's an element of discretion, I guess, at least to that part, although the evidence code doesn't seem to put a time limit on any of this stuff. I don't know where that comes from. You know, the other thing about the remoteness issue, if I could just say this, the state made a big deal out of that, citing the Penn-Laver case, but that had to do with whether something was remote, whether something was admissible to show future conduct. Here, we're using this to show state of mind, which was pretty clearly her state of mind. Let me just say that before I get into my rebuttal time, that I think the issues about the divorce texts and all of the other texts, there's a common theme in this. The judge is mistakenly applying the hearsay rule, not understanding statements made for plan or intent, excluding the statements, and then saying it really makes no difference because the defendant got a chance to say this in his own words to the jury. But let me remind you, at trial, the prosecution said to the defendant, the prosecution made the point that the jury shouldn't believe the defendant. The prosecutor asked the defendant on the stand, Mr. Ruschel, would you admit that you're the one in this courtroom who has the most to lose by the outcome of this trial? Mr. Ruschel said, yes, sir, I am. So on the one hand, they're saying to the jury, don't believe this guy. He's completely interested. He has 30 years to lose here. And on the other hand, now counsel is saying, well, it doesn't matter. The defendant got to tell his story. That doesn't add up. Well, let me save the rest of my time for rebuttal.
Thank you, counsel. We'll hear from the state now.
May it please the court, Virginia Harris on behalf of the state of Florida. I'll start with issue 1, and basically the state's position is that this is not preserved, it's abandoned, it's waived just about in every way you can think of. Defense counsel filed a general motion just asking for records, all of the records. Then she goes to the hearing and says, after the state says absolutely not, she clarifies, and I'm going to read this. I would agree with Mr. Byron. If this court views I clearly, when I wrote this, I should have been more careful. I'm not interested in finding out, years of Mrs. Ruschel's medical history. I'm very much concerned with finding out the seriousness of her alcohol dependence, the amount of alcohol she may have consumed on the date in question, and the specific medication she may have had in the date in question, so that I can possibly further use an expert testimony to determine whether or not those have had an effect on her. What the combination of the two things would have an effect that would be helpful to the jury in this instance. I am not at all interested in finding out, anything beyond how she was that day, February 2nd and 3rd, and how she is in August when she will be testifying. She makes it abundantly clear that she does not want any of these things that defense counsel is now arguing that they should have had on appeal. In fact, she is the one that suggested to the court that he do an in-camera review. In fact, the prosecutor then says, I would like the court to determine first, follow her suggestion, if this is relevant, if it's privileged, and if it is privileged, did she waive it? So if defense counsel didn't agree with that standard being used, it'd be a great time to admit that. Then the order is issued weeks before, about a month before the trial, and defense counsel never objects to any of these findings, including the standard that was used. The Coleman case, which is a child hearsay case, talks about how in that case, when defense counsel makes objections based on child hearsay, and then an order is issued, and defense counsel has a problem with the findings, that it has to notify the court then, that he can't just sit on his hands and sandbag and go to trial and then complain afterwards. And I think that that would apply here. So this is just completely unpreserved. And then this is kind of problematic because as to some of the claims that defense counsel's arguing about the suicide and the bias and the outbursts and all that, you almost can't even evaluate that because it wasn't before the trial court. The trial court wasn't looking for those things. So I don't understand how this court can do that, because there's no way to know what the trial court would have done if he'd been asked to look for those things. I think defense counsel confined themselves by doing that. I made a harmless error argument in the event on that issue that this court decided to go looking for it itself. That's really the only thing I can do here. But I don't think this court can evaluate those claims at all. As to the ones defense counsel did ask the court to look for, she admitted that she pretty much already had this evidence. She says the defendant or the victim admits she's drinking. There's admission she has an alcohol problem. She's an alcoholic. We have receipts from the restaurant. They have video surveillance from inside the house showing her drinking. We have this. I just don't think we should be limited to her admissions. And we're going to get an expert to opine as to how all of these could have interacted and affected her memory. So the judge looks it over, says the only thing I find of limited relevance because of the context and because it's 3 months before the incident, which is out of the time frame defense counsel asked for, which is likely the reason they never objected to any of these findings.
Can I ask you,
I'm sorry.
the psychotherapist privilege itself, I understand your argument on preservation. Was that privilege waived with the disclosures in the civil case?
It looks to me like, based on your case law, that it was. Because you have a case law that talks about when it's waived in a criminal case, but not in a civil case, that one waiver at one place makes it, open for the other. And it looks like it's one of the exceptions. I did put, since you have some information that I don't have that's redacted, and I purposely didn't request that because the parties agreed to keep that confidential. But I did note that if for some reason you saw in the order that there was an agreement amongst the parties that it only be used for the civil case and not the criminal, that we would not agree that was waived. But the trial court said there wasn't. So it looks like it probably was in that case.
If it's been waived then, and given that we're talking about discovery, we're not talking about the admissibility of the evidence yet, shouldn't it have been disclosed?
No, this court's case law and case law from around the state, a lot of some of it's in my brief and also in the judge's order, seems to indicate that you do an in-camera review even if it's waived. I would presume the purpose of that is to make sure that something wasn't overproduced. Like, say, for example, just go through and make sure everything the defendant gets is what is waived.
I'm familiar with Zarzar and the other,
Right.
Civil family law cases. Are you aware of a criminal case where we've required or another DCA's required that in-camera review?
No, but even if you felt otherwise, then it would be on the defense because she's the one that told the judge she wanted the in-camera review. She suggested it and said she had no objection, so it would be invited error. And then finally, and I think I briefly, there's plenty of evidence of all this stuff. I mean, I have never, I've been doing criminal for a while, seen a defendant go on and on about the prior bad acts of a victim. I've never seen this kind of leeway. The prosecutor said it was 8+ hours of grievances. I have read this trial twice. All he does is with every breath insult her. I tried to give you a snapshot of that as best I could. All he talks about is how she was drank and she beat him up and caused all these injuries.
But that kind of draws attention to the issue that appellant's counsel brought up regarding the text. And how do you respond to the point that, granted, the appellant himself testified to much of this evidence, but that those texts would have been invaluable, certainly relevant to corroborate from her own words that kind of testimony?
Are you talking about the emails about the suicidal
Right.
ideation? It's undisputed. It's not just the defendant. She agrees that she was depressed, that she sent him suicidal emails, that she threatened to drown herself in the pool. The defense counsel said, you threatened to shoot yourself with a gun. And she said, well, I don't have a gun. And that's when it gets stopped, because apparently the judge had agreed that certain things from October the October before could come in, but that anything before that was not relevant, that it was too far in the past and therefore not relevant to, because what we're trying to decide is.
So your argument is, on that point, is harmless error?
Right. And this is not in dispute. It's not just him saying it. She says, yeah, I was depressed. I was seeing a counselor. I sent him emails saying I wanted to kill myself. She doesn't dispute any of this. She even agrees to sending him an email closer in time saying that the therapy and the hormones and counseling aren't working. This is not something that's in dispute. And the same thing, I think also when they talk about state of mind with, I guess, the divorce issue, that is not in dispute either. The victim testified that in writing, the defendant always said he was fine with a divorce, but that he wasn't really in person. The defendant also testified, in writing, I always said I was fine with divorce. And then his own lawyer says, but did you want a divorce? No, not at all. So there's no dispute in the testimony. It's not just the defendant, it's her too. So what do we need to bring in all this hearsay of him saying he's fine with the divorce when they're both agreeing that in writing he was, but actually he was not? So that doesn't make any sense to me. And so really, the judge gave a lot of leeway in this. I've never seen so much leeway given to a defendant. And the interesting thing is they prohibited the victim from presenting her side of the story. Because the defendant claimed that he was defending himself, he was allowed to trash her. But because she never said she was defending herself, the judge precluded her from talking about the prior bad acts of the defendant. So you will see when she's getting cross-examined, she'll just be like, I don't know what to say. I'm not allowed to discuss this. I know this looks bad, but I'm not allowed to discuss this. This gets said over and over again because she's been ordered not to talk about it. So the jury was given the events going all the way back to when they were dating of how bad the victim was and the worst possible light to her, and without her really being able to say anything about the defendant at all. And it's ironic, I think the state's, the best evidence for the state of the defendant's guilt is his own testimony. I mean, he just goes on and on insulting her. You got to remember, his primary defense is he did this because he loves her so much. I mean, he did all this lying to police, tampered with all this evidence because he loves her so much. Well, how can you say that and then go around, this man remembers every little thing she did wrong, going back to when she was dating, they were dating, they've been married for over 10 and a half years. He's complaining about having to pay for the dates. He's complaining about having to pay off her credit cards, how he had to pay for the wedding even though she had 40 years to save up. The detail with which he remembers every possible bad thing she's done, unrelated to the violence, shows how much he hates her and how much this has been building up. That's why he lost. The defense, it's almost like their real defense was that they were hoping the jury would pardon him because she was such a bad wife. But the risk of that is that that they just hear how much he hates her. There's no more convincing evidence in this case that he wanted to kill her than his own testimony. And
Can I ask you about the text and emails with regard to the divorce? Is it your contention that they don't fall under the state of mind exception, or are you saying that they don't fall under the state of mind exception, but even if they do, they're too attenuated to be admissible?
And for the divorce, they're not in dispute. So any error would be harmless. In other words, what you would do is if the victim says, the defense brings up, well, hasn't the defendant been saying all these years that he's fine with the divorce in writing? And she said, no, he wasn't. Well, then you'd want to introduce that to impeach her. But she didn't say that. She said, yeah, he did. In writing, he said he was fine. That's not how he really felt. And he said the exact same thing when he was being questioned. That, yeah, in writing, I said all these things, but I didn't really. He said, no, not at all. So there's no dispute regarding this. I don't understand why. So it's not just that it's old. It doesn't impeach the victim. It doesn't add anything. So it's not error, and even if it was, it would be harmless because there's not a problem here.
And Mr. Padovano talked about the veneer case out of the 4th DCA. Could you, and I think you mentioned that in the answer brief too, but can you just,
Yeah.
why that's not applicable on the suicidal?
Well, and first of all, in the veneer case, they excluded entire category of evidence. They didn't allow the evidence in at all. It wasn't, and there's no indication in veneer that this was old evidence. And this case, and quite frankly, I think the judge would have been within his discretion to exclude the stuff from October. I mean, this happened February 2nd and 3rd, but he didn't. He let all that stuff from October come in. So he granted them leeway on that. It was everything past that he said, no, that's too far in advance. So in this case, an entire evidence category was not excluded. It's undisputed that she was suicidal by her. And the more recent, the October 2017, she agreed to all that. Yeah, I sent these emails. So it's completely different. In fact, I think it's Million case that I talk about on there distinguishes veneer by saying in veneer they actually excluded an entire category of evidence. And so, let's see, I think and then I just want to talk about the defendant's version of events real quick that also shows that it's harmless. You have to understand that I think the main reason that he lost here is because of his own testimony. I mean, he's claiming that this woman is 5'2" and like 109 pounds. He's just under 6 foot, 180. He's claiming that this woman who was a blackout drunk, which the video surveillance shows she's not. You can see her walking around, giving her dog a water bowl, getting her reading glasses, changing. I mean, she's not blacked out drunk by his own narration of the video. But he's claiming that he went in there, she got the drop on him while she's in the middle of the bed, which makes you wonder why he couldn't just walk out, and that they're struggling over this knife, and that she just falls back and he accidentally stabs her in the stomach. He doesn't know how this other injury up here in the above her clavicle happened. He never saw that, even though everybody else says they're gaping holes and could easily be seen. And that then after he gets this knife away from her, that they're just lying in bed for hours talking about all the fun things they're going to do in the future, the vacations they're going to take and all that. And nobody notices that she has, I mean, she noticed the stab wound to her stomach, but they didn't know about this other wound that's right here. He doesn't notice the blood. He doesn't notice the feces. He does admit she vomited later on, but he doesn't smell or notice any of this. My favorite part, they never looked at their injuries. They never went to the bathroom that's right there to check on his wife. They're just lying there chit-chatting. Then he says that she starts getting freaked out that she's going to go to jail because she's afraid of going to jail. So they decide to make up this story of an intruder, which it was her idea, but he came up with the details. And then they practice the story, which if she's a blackout drunk, I'm not really sure how he could trust her to remember all of that. But at this point, she then gets up and causes deep 2 gashes to her wrist with her non-dominant hand. And these are so deep, they're to the bone. And he just couldn't stop her from doing this. At this point, they decide on this story. He takes an additional 25 minutes to call 911. This is his own testimony. He's busy tampering with evidence and everything, not worried about her life, this woman that's bleeding everywhere now with a serious injury, but tampering with this evidence. Oh, but it was just for her. Apparently keeping her from getting arrested is more important than saving her life. And then he repeatedly lies to the police, and most of these are recorded, telling extremely detailed lies about a masked intruder and with gloves and how he fought him off. The police describe him as being eerily calm while he's talking about this, which is really strange because even if he was telling the truth that his wife did this to him, why would he be calm? And it's just so the prosecutor just destroys him on cross-examination with all the times that he lied. His version version of events is preposterous. The police said they could smell the feces and the urine as soon as they walked in, that it was so overwhelming. She's lying there soaked in blood, easily viewed injuries. She's got vomit on her face and her hair and everything. They couldn't even find a pulse when they got there. His version of events is preposterous, and that's the reason that he lost. It's not really him versus the victim. It's really him versus his own implausible version of events, and to some degree, him versus the police and the medical professionals.
Are you recounting all this for a harmless error?
Yeah,
consideration?
in general, for any of them. I mean, that's really, he was able to provide his defense. He was able to provide it in the light most favorable to him, and he still lost. Are there any further questions? Okay. We ask that you affirm.
Thank you.
Well, I think the court recognizes that that long argument about her being 5'2" and his story being preposterous is a trial argument, really not. I hope the court can focus on the issues that are presented here, which are issues of law. Let me address her counsel's statement that the divorce text wouldn't be admissible as impeachment. We have a long-running record of these texts, which he is saying, well, first of all, let me just say, they would have contradicted the prosecutor's statement and also Susan Rochelle's statement. The prosecutor told the jury on more than one occasion that Mike Rochelle wanted to kill his wife because he was worried about having to give her half of the money in the divorce. He wanted to eliminate her so he wouldn't have to give her half the property. To know that he was okay with the divorce in contemporaneous exchanges that were made between the parties would have been invaluable to refute that claim. It was also impeachment of Susan Rochelle's testimony. She testified that he climbed on top of her and he said to her, I'm going to kill you right here. I'm not going to let another man have you. Wouldn't his willingness to grant her a divorce, and I say grant her, I mean, we all know that you don't have any choice but to grant a divorce, but his text clearly showed that he's okay with it. And I would also say, too, that impeaches her testimony because she's saying essentially that he wanted to kill her because he didn't want her to be with another man. At the same time, you've got 30 or 40 texts spanning over a couple of years talking about his willingness to get a divorce in intricate detail. He says, you can keep one house, I'll take the other, you can take your pick, on and on and on and on. And, you know, counsel says, well, he got to say that. He got to say that. Sure, he did. But he's the same man the prosecution said the jury shouldn't believe. Think about the value those texts would have had being contemporaneous in real time in the discussions these people had about their marital future. Instead, they're asking us to rely on statements he made during the trial when he was obviously not the most impartial witness in the case. You know, the case, counsel said that these things were all harmless error. You know, I don't agree with that. If this entire trial was presented in a way that was not even remotely close to what happened, there was a lot negative said about Mrs. Rochelle. If the jury had seen the text, they would have seen with their own eyes that there was a lot negative about Mrs. Rochelle. To say that it was harmless because he got to repeat some of it himself, it doesn't really answer the question. And let me just say there's sort of like a context issue here too. You have all of these texts about the suicide, for example, intricate details about how she's going to do it, why she's going to do it. And then at trial, they make it look like, well, this was a passing thing. She was just upset about her daughter-in-law's wedding, a one-off thing. The jury had a right to see what actually happened if this was not hearsay. And it was not. I disagree with counsel. This was his plan, his intent, his plan. So, I mean, I started out by saying there were a lot of errors here. I stand by that. It was a trial that was conducted in a way that it shouldn't have been. I don't think the judge bent over backwards. I think, if anything, the defense was kind of stymied pretty much at every turn from doing what they wanted to do and what they had a right to do. Well, thank you for your time. We request that the court enter a reversal for a new trial. Thank you.
Thank you for both of your arguments. Court is in recess.
All rise.